Professor Rubenstein.
Actually, Rubenstein.
Rubenstein, I beg your pardon.
Just for the record.
Rubenstein. Are we broadcasting?
Right.
Yep. I now welcome Professor Kim Rubenstein to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Yes, I'm Kim Rubenstein, and I'm here on my own personal private capacity.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make an opening statement before we proceed to discussion.
Thank you, Chair, and thank you to the committee for giving me the opportunity to present to you this morning. This has become an area of great and continuing public importance, and the Parliament's role in reviewing this legislation is fundamental, as indeed is the role of the Independent National Security Legislation Monitor, and many of those who are providing evidence today did so a few weeks ago in relation to that body's responsibility also for reviewing those provisions. And the Independent National Security Legislation Monitor is already on the record for his preliminary views in relation to recommending the repeal of the operation of law provisions. But my aim this morning is to return to some fundamental concepts that I have been placing on the public record since the original proposal to include greater deprivation provisions were proposed and mooted in relation to the Citizenship Act. I have been working in and writing on questions of Australian citizenship since the early 1990s. And while the Law Council said that it's only in recent times that this has been creating much more public discourse, I would say that these are continuing issues that are fundamental to the nature of a Western liberal democratic society, and it is at the points such as these that we actually have great attention to the foundational nature of these concepts is one that places great responsibility on you as our representatives to be very thoughtful, and this committee's role is a testament to the importance of this process and of thinking now down the track with the operation of those provisions now having been enforced for a period of time to properly reflect on those, and I would like to very much contribute to that reflection. So my aim is to outline a few of the continuing concerns that I've been placing on the public record in relation to using citizenship as a tool for dealing with our security environment. I want to emphasise the problematic nature of the concept of allegiance as a tool for determining who is and isn't a member of the community. I will return briefly to the continuing constitutional rule of law notions that are profoundly impacted by this legislative step. But most importantly, and with the time that I have, I would like to take the committee to the submissions of Home Affairs and DFAT in relation to the problematic nature of these provisions in relation to our security environment as fundamentally now adding to the undesirability of these provisions as a form of security control in and of themselves, but as I will now return to the most fundamental aspect, which is the alteration that this legislation has in terms of concepts of citizenship in a Western liberal democratic society. And I might in fact refer also to the submitter number 1, the Executive Council of Australian Juries submission in framing what I'm about to say, because in relation to its opening statement of general principles, it refers to the fact that the most effective measures in relation to protecting the Western liberal democratic framework from terrorist threats are those that are solidly grounded in the very values which most terrorist groups seek to destroy and which Australia seeks to uphold: freedom, justice, democracy and the rule of law. And those concepts of democracy and the rule of law are grounded in a concept of equality of citizenship between the state and the citizen. And what I mean by that is between 1901 and 1948, the status of full membership in the Australian community was subject of the Queen. Subject of the Crown, and the notion of subjectivity is imbued with a notion of imbalance of power between the Crown, with the divine power of the Crown, and the subject. The subject was subjected to the will of the Crown, and that was was fundamentally an unequal status. When we moved to citizenship on the 26th of January 1949, not only was that a common move around the Commonwealth Dominion, but each of the Commonwealth countries signed on to this framework for the Act, that reference and move to citizenship was a recognition of a fundamental rule of law democratic notion of an equality between the state, the executive, the representatives of the citizenry, and the people. And that equality of citizenship is fundamental also to the rights that are associated with the status of citizen. So earlier this morning, when the Law Council were talking about the fictitious operation of law nature of these provisions, what they're actually highlighting is a disjuncture between status, the actual status of citizenship, and the rights that flow from citizenship. And the operation of provision sections are highlighting that you can lose the status, but until the rights that flow from that status are affected, you are in a limbo position in terms of what that actually means for you as a member of the community. And I can come back to that shortly. But I do want to emphasise the point that citizenship and the power to take away citizenship has to be grounded in fundamental notions of democratic rule of law procedural frameworks, and that it should only be in the rarest frameworks or circumstances that citizenship can be stripped. And until December 2015, those narrow frameworks were fraud in relation to the obtaining of citizenship, and that is a very clear notion. If you come to a state and you say, I want to be a member of your state and this is the basis upon which you can make the decision as to whether I come or not, then if the state finds out that the very material that you provided and on which the state has agreed to you becoming a citizen have changed, that can be a change in terms of revocation, those Section 34 revocation on the basis of fraud, or fraudulent processes that do not lead to the authenticity of the acceptance by the state of you becoming a citizen. The one other remaining provision that was there, which was enlarged upon in these provisions, was that if you're a citizen of another country, so it was the same protection against statelessness, and you fight for a country that is directly at war with Australia, then you would lose your Australian citizenship. And that was the only context that was understood to be appropriate because, and we can understand this, you are seeking to get rid of the state as an entity, as a matter of international law when a state enters direct warfare for the aim of taking over that other state. It is about the end of that nation state. So you can understand that concept that if you are directly seeking to get rid of the state, as opposed to exercising or conducting yourself in activities that the state may not like and deem as inconsistent with the values of the state, that was the only scenario. And I would argue that should be the only scenario, and treason is the other framework where you're seeking to undermine the actual existence of the state. And this comes back to a fundamental international law concept of the sovereignty of states, and that citizenship is the way into one's protection of rights through the state in an international framework. So, with the greatest of respect to all of our current members of Parliament, one could in future deem that this whole process of introducing this Act showed a lack of allegiance to Australian values. And in future, you could all be potentially subject to deprivation provisions because a future government might deem that an Act that sought to undermine the very foundational principles that we're supposedly seeking to represent is something that is deemed to be a lack of allegiance to Australia. a significant change in one's relationship to this country because of an undermining of the very foundational. Now, that might seem far-fetched in your current mindset, but the point I'm trying to make is that if the state is given the power to, at its own will, decide what is deemed to be allegiance to the state, we have started along a slippery slide towards a very different democratic framework, and that citizenship is fundamental to what I would say are foundational rule of law notions. And I'm very keen to hear what you've got to ask, Mr. Wilson.
Mr. Wilson.
Thanks for that. I don't disagree that citizenship is fundamental at all, and I doubt any committee member would, although I think some of us might raise some questions about your last statement. But can I just clarify?
Yes.
Do you think that the basis intent of what this legislation is seeking to target, where people engage in terrorist activities or engage in foreign conflicts, theatres of war,
yes.
Do you think they should be able to lose their citizenship?
No, I don't. I think citizenship should be kept out of the framework of security, the package of security mechanisms, because I think once you start using citizenship as part of the framework, you are actually then dealing with a much more problematic issue on a range of different ways, social cohesion and so forth. So I would say that we need to deal with those problems using the criminal law framework first and foremost, and that citizenship should never have been brought into the framework for this important activity.
So essentially you oppose the proposed legislation, even if there were to be, for instance, the concerns raised by the Law Council around procedure and process,
yes,
you would still oppose it?
My starting point, and then all of those other aspects add to the problematic nature of it, but I think it really is important to engage with that much more fundamental concern about these provisions in relation to altering the nature of status of citizenship, and to come back to your last question in relation to the Law Council about what I would call differentiated citizenship. So a notion of equality of citizenship is fundamental. In order to protect our responsibilities in terms of questions of statelessness, this bill differentiates. But that also just shows the problematic nature of using citizenship as your frame for dealing with terrorism, because then you are undermining your rule of law notions of saying you and I can do exactly the same thing. I'm a sole Australian citizen. Well, obviously none of you can be dual citizens. Or there may be some members of Parliament currently who are dual citizens who may soon find out they may not be members of Parliament. But in those scenarios, there is a differentiated citizenship in Australia, and that goes against the whole trajectory of our move towards citizenship.
Okay, so let me ask you this question then, which is, from what I understand of your evidence already, if somebody engages and goes and supports a foreign entity to
yes.
essentially attack Australia
yes.
And end the nation state or the state in Australia,
yes.
it is a legitimate justification to deprive them of their citizenship.
Yes.
If they go and fight in a foreign theatre of war where they indirectly do that,
yes.
you do not think it meets that threshold? And at what point then
yes.
do you go from this indirect to direct, where you're actually engaging in trying to end the Australian state?
So I think in terms of the indirect, then because that framework is so difficult and nuanced to define, that it is too undermining of our democratic framework to go along that path. I think it is
it has to be explicit.
It has to be explicit, yes. And that explicit might be in a statement by an individual seeking to do that. And if there was some framework where they were saying that they were seeking to work against and undermine the Australian state, as opposed to conducting activities that we deem to be inappropriate and inconsistent with Australian values. Because once you go down that inappropriate and inconsistent with Australian values, my opening statement in relation to your activity in passing a bill that seeks to go against Australian values comes into the measure, but it can be even less dramatic than that. It can be all of the dual citizen paedophiles in Australia. Here is a clear way of removing them.
Okay, so just to be clear,
Yes.
Treason, sabotage,
Yes,
espionage,
yes.
foreign interference, they're on the statute books, obviously. They meet the threshold for you?
Of directly seeking to undermine the state, yes.
Okay, but joining forces with a
another foreign
unsavoury entity.
Yes, would
Yes.
not, yes, yeah.
Sure.
Can I just ask a follow-up
Yes, sure.
question there? Most of your comments pertain to another group which has a beef with a particular country.
Yes,
So that particular country in your argument is Australia.
yes,
When we're talking about Islamic terrorism,
yes,
the fundamental proposition of the jihadists is that the whole system of Westphalian nation states is invalid and democratic nations are abhorrent,
yeah.
and that an Islamic caliphate is
Yes.
the only legitimate
Yeah.
state. So do you accept that somebody who has signed their allegiance to Islamic State
Yes,
and
I do.
opposes the existence
Of any
a
democratic state.
Westphalian
Yes.
nation state
Yes, I do.
meets the threshold?
And that was my proposal at the time, that the Section 17 that previously could be adapted to that scenario. But everything else, and it's a lot else that has been introduced, is undermining of our democratic framework.
So the 30 inmates who are currently in Supermax, who are intensifying in their religious fervour as opposed to in any way renouncing it, if they
Yes.
had dual citizenship, you would support
They
that
would
being
potentially
revoked?
within that framework, yes.
Okay, thank you.
But I think it is really important for this committee to be wary and concerned about using allegiance as the framework, because, and in fact, and I want to correct the Home Affairs submission, they make a point that the Australian Citizenship Act is framed around notions of allegiance. Now, this is one of these unclear High Court cases that we really need to understand the constitutionality of the provisions. But can I point you all to the preamble of the Australian Citizenship Act, an act that I was involved, as I've told you, in the redrafting of in 2007. There was a significant change in relation to the language. Allegiance does not appear in the preamble to the Australian Citizenship Act. It says in the second part that the Parliament recognises that persons, this is in relation to persons conferred Australian citizenship, enjoy these rights and undertake to accept these obligations by pledging loyalty to Australia and its people. It took out the word allegiance. And our book on Australian citizenship law, which I've referred you to in the submission, talks about the changed notion of a simplistic understanding of allegiance to a singular notion to a nation state, to, in a globalised world, a much more nuanced and multifaceted notion of allegiance, where we as a country accepted in 2002 to change the prohibition against dual citizenship. So it is only in Parliament that a person in Australia cannot be a dual citizen. In every other respect, our citizenship law took on board, as did the change of the terminology of loyalty, of the capacity to have allegiance to more than one nation state without that, or loyalty or connection, without that undermining your Australian citizenship. And I fear that these provisions, my view is that these provisions take us back and away from and undermine what is, in a multicultural and globalised nation, a really fundamental matter. But given that I only have a few minutes left, can I please direct the committee to the Home Affairs submission and also DFAT's submission?
Before we do, Chair, can I
Yes,
just
sure.
ask a question that relates
Yes,
to the one
absolutely.
we've just had? And I guess before we move on too much,
Yeah,
two
sure.
things. For those sort of playing at home, the difference between allegiance and loyalty in the way you're using it is that you can have allegiance only to one nation and loyalty is consistent with a system where you can have multiple citizenships. Is that right?
No, so what I'm saying is our concept of allegiance, the concept of allegiance that has been relied upon for the purposes of the amendment to the Act is underpinning a notion of loyalty only to one country, whereas in relation to what the High Court may say about allegiance and broader normative views of allegiance, we have as a society moved to having multiple connections to more than one nation state. And the example that I use is a change from thinking of citizenship as marriage, where in our society monogamous relationships are the ethical norm, to thinking about citizenship as parenthood. We do not ever challenge any parent from deciding to move from having one child to having two children. That there is never a question mark that means that your sense of connection to any of those children is undermined by having more than one. There might be instances where there is a direct conflict between your children that you manage, but it is only when that direct conflict, which I would say is if you're trying the Cain and Abel scenario of one trying to get rid of the other, in this scenario is where citizenship should be lost. But in every other respect, we understand that we can be connected to more than one nation state without that undermining our sense of connection to any of them individually.
Okay. Is that something that's supported by the High Court authorities as they currently stand?
Well, in relation to a recognition of international law, which is what the Section 44 cases are all about, that an individual can in fact be a dual citizen as a matter of reality, and that is the norm in our country, which is why it is so difficult to encourage anyone to nominate for Parliament if they have any other country of citizenship.
So just to be clear,
yes.
Does the High Court endorse the conception of citizenship as parenthood?
Oh, well, there's never been a direct framework for it to explicitly use my analogy, but the High Court, in affirming the legal framework within Australia, recognises that Australia moved in 2002 to enabling dual citizenship, but it's not a matter that the High Court has had to determine.
So the legislation you were participating in had that in mind, but it hasn't been determined by the High Court yet. Have I got that right?
It's not a question directly before the High Court in any context, but it may become one in relation to the lawfulness of this legislation under the Aliens and Naturalisation Power.
Right.
So it could come before the court.
Can I ask you this?
Yes.
It was helpful to have you go through the traditional bases upon which one could lose citizenship.
Yes.
But it strikes me that they are reflective of notions of war and conflict.
Yes.
That in a sense are backward-looking or history-looking.
Or outdated.
Outdated, yeah, very good. And that perhaps that the nature of warfare and the nature of international conflict has changed.
Yes, I agree with that.
In a way that means our conceptions of citizenship and what it means to act contrary to it may also need to evolve. Do you see any scope for the way in which we conceive the nature of conflict
Yes.
evolving in this definition?
So I, as I had said earlier, I think that the earlier Section 17 or Section 35 had that potential with a modified amendment to acknowledging those criminal sort of frameworks that identified treason and activity that is seeking to undermine the actual foundations of that state, as opposed to the way it's framed now, actions that are deemed to be inconsistent with Australian values.
Okay.
Yeah.
Thanks, Joe.
We'll go to Senator Keneally. Mr. Dreyfus. Yeah.
Thank you, it's been very helpful. I have one quick question.
Yes.
You say in your submission that you believe this policy move is counterproductive.
Yes.
It may influence further perceptions and alienations of otherness
Yes.
from and towards dual citizens
Yes.
in Australia. I wonder if you've considered, or if there's any evidence either here or overseas, that in fact a law like this may have the unintended consequence of propelling people who have dual citizenship to relinquish their second citizenship
Oh, that's a very
in order
interesting-
to enjoy
yeah.
the protection
Yes.
of Australian citizenship only. That
Yes.
is, they could avoid being stripped of Australian citizenship
Indeed.
simply by renouncing another one.
Yes, I think the notion is which country gets in first, or in yes, there is without doubt the new framework for someone who is a dual citizen to consider relinquishing that other citizenship, the one that they deem as lesser of value to them in order to protect their Australian citizenship. Or, as I've written with my colleague, former student Neve Maguire, the irony is in Australia that the more citizenships you have, the more vulnerable your Australian citizenship. So that normally you would say in relation to anything, the more you have, the better it is. the situation in Australia now is the more you have of citizenships, the more vulnerable your Australian citizenship is, which again goes against the fundamental equality notion of citizenship. But I also think beyond your question, Senator Keneally, is the more profound psychological social cohesion question, which is for children growing up now in an environment where people who are dual citizens are seen as other, and in relation to Honourable Senator Abetz and Senator Fawcett's questions in terms of the fundamental Muslim concept, that there is the added discourse through legislation that those people who are deemed as dual citizens through that identity are subject to more vulnerability, and therefore the fragmentation of a sense of connection to Australia. Research would need to be done on to what extent that adds to radicalisation, or the vulnerability to further radicalisation, which of course is one of the supposed principles of this Act to protect against that notion. But perhaps, and I would argue it would be valuable to have that research done to see whether there is in fact that unintended consequence that we're actually making Australians more vulnerable internally to those individuals being more vulnerable to radicalisation, which is very concerning.
Thank you.
But
I think there were some other
oh,
questions.
yes, right.
Just a quick one, thank you, Chair. Obviously, we've known each other a long time,
Yes,
Professor,
indeed.
and I want to pay tribute here to the wonderful work you've done,
Thank you,
particularly
that's
in the
very
area of genocide research and your writings. And so that is the point that I want to raise with you now. As you know only too well, there are various levels of war crimes, prosecution and regimes, some of which obviously with citizenship comes jurisdiction for some acts that may be perpetrated overseas that we can then prosecute and deal with those people. But there's also universal aspects of jurisdiction in the war crimes regime. But in your work in genocide, and we have the Genocide Convention.
Yes.
If we have an Australian citizen who, for example, perhaps Prakash may have been engaged in or associated with genocidal activities against the Yazidis,
Yes.
How would revocation of that citizenship and basically effectively disowning a citizen mesh with the responsibilities to act and deal with violators, perpetrators of genocide obligations, and how our obligations fit in that respect with that international regime for dealing with genocide?
Well, I think the answers come through the DFAT and Home Affairs submissions in the sense of making it much more difficult for Australia to be able to fulfil its responsibilities internationally in prosecuting and managing terrorism in an international context. And I think that Neil Prakash scenario, which is the only one that the committee really has in terms of public knowledge of someone who has been deemed to have lost their Australian citizenship. And I would, on the record, say that as a matter of law, he continues to be an Australian citizen, in the sense that if you draw together international law principles, that it's the sovereign right of a nation to state to determine who its citizens are. So it is Fiji's sovereign right to determine whether he is or isn't a citizen. The High Court has affirmed that categorically in relation to Section 44 of the Constitution. It doesn't matter whether an individual thinks they are or not a citizen of another country, and we're going to have another case before the High Court to determine whether another country deems that person to be an Australian citizen as a matter of a citizen of that country as a matter of law. That is the undeniable reality of whether someone is or isn't a dual citizen, whether that other country recognises them as a citizen. Now, this scenario with Mr. Prakash is really significant in terms of the fact that on a range of levels, in relation to DFAT's material, they talk about diplomatic consular assistance. So one would imagine that Mr. Prakash, until they made the determination that he'd lost his Australian citizenship, was receiving, if the government chose, consular assistance. It would be interesting to ask DFAT, who would have, one would imagine, and this would be an interesting question, have had the responsibility of communicating to Mr Prakash that they would no longer be giving him diplomatic consular assistance because he was no longer an Australian citizen. Who was given that responsibility? What is the impact on that individual in having to inform that person who they may have been meeting with on a regular basis that they will no longer be meeting with them? I mean, I think there are also ramifications for the Australians who are responsible for the operation of these provisions, of the impact on them of that responsibility. But more significantly, in terms of the rights of Mr Prakash, if that is incorrect and Australia is actually breaching its own law by continuing to treat him as a non-citizen when he is a citizen, there are significant rule of law notions here that as a state we are ensuring that our executive is conducting unlawful activity. And it's on the record, as soon as Fiji said that that he was not recognised by Fiji as a citizen, my view is, as a matter of the rule of law, that the minister should not have continued to act as if he was no longer an Australian citizen. And this is made more pronounced by the fact that even though as a matter of law Mr Prakash has a right to seek judicial review of that determination, how in practice is that going to happen? How in practice is someone in jail who is no longer getting consular assistance from the very country that is responsible for him going to affect that right? And this is where I talk about the significant consequence of a law like this. We are, as a nation, saying that your status may continue, but we will not give you the rights that associate with that status. I think that is so fundamentally a disconnect with any notion of allegiance to Australian values.
Just noting the time, Mr Dreyfus, if we could move on and then we'll Senator Abetz.
I'm noting the time. Thank you very much for your contribution, Dr Rubenstein, and we have the benefit of the published transcript of the evidence you've given just recently to the Independent National Security and Legislation Monitor on the 27th of June.
Yes.
So I won't go to any of the matters that the Monitor asked you about.
Yes.
I was going to ask the general question whether anything's happened since December 2015 that's affected your thinking about the constitutionality, effectiveness or desirability of these provisions. And you've pointed to Prakash,
yes,
which I take it from what you've already said to the committee this morning, you regard as a significant event.
Yes.
It happens to be, I think, the only example of a cessation of citizenship that the Minister has been prepared to talk publicly about.
Yes.
But I would ask you that general question. What's
Yes.
happened since, if anything,
Yes.
since December 2015 that's affected your thinking about these provisions?
Well, I think the attention to the Citizenship Loss Board is the other factor that is another representation of our the significant concerns about the rule of law framework under which we operate. My view is that the Citizenship Loss Board is purely an advisory board. It's an advisory board to the Minister in issuing those certificates. I don't believe that it's actually exercising any power per se, but I think that that is also problematic in relation to the framework within which the Minister is currently operating, which is all that the Minister is doing is not making a decision about whether someone is or isn't a citizen. They're making a decision about whether the rights that go with citizenship will be provided to that individual because of the operation of law nature of the statute. And I think, again, that this actual operation, of having to operationalise these operational law provisions, adds further concern to the fundamental unconstitutionality of the provisions, but the fundamental concern for us, all of us as Australian citizens, is the potential for the executive to be making these decisions that speak to the very heart of a democratic society. We only have to go back to Hannah Arendt's fundamental statement after the Second World War. Citizenship is the right to have rights. It's so fundamental to a democratic society, which is why my starting point is we should not be using the Citizenship Act to deal with these fundamentally important security measures that the state should be generating all its energy in relation to the criminal framework. You can see I feel quite profoundly about it. It's both professional and I guess personal to my sense of Australian identity that this is not the right path to be following. And as a parliament, you have the capacity to state that you are committed to security protection, but not at the cost of the very values that we're seeking to protect against, that we deem those terrorists are undermining. Because then, in a way, they're successful, that we are undermining ourselves in order to protect against the values that we say that they are threatening us with.
Dr. Rubenstein, the Parliament of Canada repealed the citizenship loss provisions that had been enacted in Canada in 2017.
Yeah.
Can you tell us anything about what happened in Canada and what was the basis for the repeal of those provisions?
So recognition of the inequality or differentiation of citizenship, I understand, is one of the fundamental reasons that that their parliament determined, a change of leadership that led to a recognition that this was not a policy. They are my understanding, but my colleague Dr. Raina Thwaites, who is more expert in Canadian matters and is appearing and may have even arrived since I've been looking forward rather than backwards, but he is perhaps more of an expert that can assist you in relation to the Canadian practice.
And finally, you wanted to say something, I think, about the submission from the Department of Home Affairs to the inquiry. Is it helpful? Do you think that the submission engages with the concerns that you and other submitters have expressed?
Well, I think it is helpful in showing that in addition to these problematic conceptual democratic notions, it has become problematic as a matter of security frameworks, that the various requirements, that the practical implications of the provisions, that section in relation to that, mean that the government is having to manage areas that it wouldn't have to manage and would be more free to protect us if not for these provisions. So that if you start off at the point that this is dubious as a question of law and as a question of a democratic society, and now we can add in, so this is a significant difference, the operational aspects of it being made more difficult for the very government bodies to be managing our security framework for the question, in light of the question that Dr. Kelly asked in relation to us being able to uphold our responsibilities in international framework. Citizenship is the link in the same way as it is the right to have rights. It is the power of the state, the sovereign right of the state to regulate citizens. We have no right over non-citizens. We have rights over non-citizens who are in our territory in relation to the territorial connection, but once an Australian citizen, a non-citizen leaves Australian territory, or someone becomes a non-citizen outside of territory, we have the extraterritorial connection, which is the foundational notion in international law for legislating or controlling those people, is lost. So it's so counterproductive on that level. We were saying that in advance as a matter of submission. We now have material before the committee which affirms that from the very departments that are responsible for administering it.
Yes. Thank you, Dr. Rubenstein, and thank you again for your assistance to the committee.
Thank you very much.
Very quickly, Senator Abetz.
Time is
Yes.
of the essence.
It
If you
is.
could please take on notice for
Yes.
me the issue that I think you raised early on about the difference between allegiance
Yes.
and
Loyalty. Yes.
Because a layman like myself looks up loyalty and I find synonym, first word, is
Allegiance.
And allegiance, I'm told, is loyalty or support to a superior group.
Yes.
I then look up loyalty and I'm told a strong feeling of allegiance.
Okay, I will send...
So if you can provide me with some insights into that, on notice I'd be much obliged.
I will send you the section of my book here.
However you answer is up to you.
Which is dealing with that very question. Thank you for the opportunity for doing that.
Thank you very much,
Thanks very
Professor Rubenstein, for coming today.
Thank you, Chair.
If you could
Thanks
provide
very
any
much.
additional information by 9 a.m. Thursday, 15th September, and of course, as always, we'll give you a copy of the transcript so you can make corrections to your evidence.
Thank you very much indeed.
We'll take a 10-minute break. Thank you.